Another example, and this is the big one, right? Not every witness in life has credibility problems, right? You do not have a credibility problem as a witness merely because you show up on the witness stand, right? Think of the most honest, law-abiding, credible person you know. They could be a witness tomorrow if they're standing at the right intersection and two cars crack into each other, right? It doesn't take much to be a witness, but just think, everyone doesn't have credibility problems. These things are vehicles. These things are items that you can go after if they present themselves. And the real world takeaway that I want you to have as it relates to credibility is that you do not just get this information. This information doesn't just happen. This information just doesn't appear in a page in a packet. This information is not something that when you show up to trial, someone taps you on the shoulder before you go up and say, by the way, there's 3 credibility issues for this witness, and they are as follows, right? That doesn't happen. This is independent research. This is having investigators, that having agents. It's having the people that go out and find it. And for you, whether it's when you learn the rules of evidence or as you're reminding yourself of some of these rules after the fact, what are you able to go after? What are the types of questions you're going to ask? If I know Mr. Peterson is going to show up as a witness against me, I need to ask the right questions. Does he have any prior convictions? Does he have any prior convictions that are of the felony kind within 10 years? Does he have any prior convictions that are crime and falsity or speak to his truthfulness? Does he have any specific acts in his past, whether they're convictions or not, that are probative of untruthfulness under 608B? Right? Has he had prior statements as it relates to this? Because I want to know those prior statements in case he sidesteps during this trial, I can whack him over the head with them under 613 or 801D1. Right? I have these rules at my fingertips, and I have these mechanisms at my fingertips because under credibility, the rules say this is what I'm permitted to do. These are the vehicles by which I can go after this information. Everyone understand? It's not like most of the other federal rules where it tells me what I cannot do, right? This is, if you want to impact credibility, if you want to ask questions about credibility to a witness, you can do it this way, this way, this way, or this way. That's it. This is what the rules allow. So you need to know, do you have information under any of those vehicles? Here they are. Perception and memory, right? A lot of them and a lot of things fit under these broad categories. Perception and memory. The odd part about the first couple, they have no rule. You can ask questions about a witness's ability to perceive or remember events, and there is no federal rule that speaks to that. So that is the My Cousin Vinny, are you wearing your prescription eyeglasses, right? That's what that is. Do you have the ability to perceive these events on that day, right? Did you get hit with a rock on the way to court this morning on top of the head? Yes, I did. Your ability to remember the events that you're here to testify with. I can ask questions, and those are vehicles that I can go after to say perception, memory, okay? The only way you know about those things is if you ask questions. The only way you find out whether you have those things available to you is if you investigate and look into whether there's any problem with their perception that day. That's the reason why lawyers in depositions, they ask questions about road conditions and the weather that day and the time of day and the lighting. They want to know about perception, and they're exploring perception. Not because in the discovery stage it would be fun to find out that all the lights were knocked out, but when they get to trial, I bring that up as a block. I've constructed a credibility block, an impeachment block, that all goes to lighting and their ability to perceive. And notice that I could craft that block and ask questions underneath that block. I'm going to talk about the type of questions in a second, but I could ask questions underneath that block that allows you, the juror, my audience, to start to make the connection already. On this street between 1st and 2nd and Mission, there were street lights. Matter of fact, there were 4 street lights. There was a street light at the northeast corner, northwest corner, southeast corner, southwest corner, and each one of those street lights that night wasn't working. That is, there was no street lights anywhere on that block, right? If I ask it in small, bite-sized pieces, you as jurors listening to this show, because I've organized it into a block and I've kept the questions short, clear, and concise on that block, light bulbs should start to go off. Thought bubbles should start to go off where you're like, hey, you know what? There's no damn light on that block, and I bet you this guy didn't see anything. You think you figured it out. So that way when I stand up in closing, we've made that connection through trial, and when I stand up in closing, I say, you remember, there was no street lights on that. He couldn't see anything. And when he had problems elsewhere in his testimony, you should think it's probably because he didn't have the ability to perceive. Same thing with bias. Bias does not have a rule, right? And why is it important that I isolate this as a vehicle available to you under credibility and impeachment? And why is it important that I say that it doesn't have a rule? Because this is how it comes up. Bias, you can actually ask anyone questions to get at information that colors their testimony, to get at any reason or motivation for their testimony. So if I do choose to ask mom questions, I can ask a question like, you're the defendant's mother, aren't you? And the reason I can ask it is because that goes to bias, even though there's no rule that allows you to ask it, right? And why is it important to know that I can do it, yet know there's no rule about it? Because what happens during any examination, whether it's direct or cross, from the other side? Objections. So if I say, you're the defendant's mother, aren't you? Objection, relevance, outrageous. I can't believe that counsel is doing this, right? Whether it's a proper objection or just an inflammatory one. My response is, Your Honor, this goes to bias. And that's proper. It's one of the things that I'm able to do. It's one of the vehicles that I can pursue in cross-examination, yet it has no rule. Your Honor, this goes to bias. Overruled, you move back, so you are the mother, aren't you? Right? And I go right back to my question. The other ones that are available, we talked about prior convictions under 609. That's an easy one, but it takes research. Right? People don't walk around with their records underneath their shoulder in a manila envelope, right? But I am testifying today, I'm on the other side, here are my prior convictions. Sorry about that. I'm trying to work on being a better person, and I've really turned my life around, but here they are. Right? That's not the way it works. You have to find them out, you have to research them, and when they go on the stand, you can explore them. I have one rule as it relates to prior convictions, right? Prior convictions are in there, and you're talking about them because they go to credibility. The rule makers have decided under Rule 609 in the federal system that there are certain convictions that a jury is entitled to know because it impacts their credibility. The rule makers have actually said if you have prior convictions of these kinds, it's a reason why we should tell the jury, and it's because we should take your testimony with a little more precaution and that you may be untruthful today as a result. Use it that way. Okay? I don't want to start out a cross-examination by saying, good morning, Mr. Peterson. You actually have a felony assault and battery, don't you? Right? There's no dance there. We don't even know each other yet, right? You know what I mean? There's no familiarity. I'm going right into a prior conviction, and it's before it matters. It's before it matters to a jury. Instead, I'd like to have another block first. Organize some other block that I have, whether it's favorable facts or whether it's something where I'm saying someone's not there. And maybe we get to a point, as we often do with testimony, that they're the only person that has personal knowledge that day. Maybe they're the only person that saw something. And maybe they stand up, right? And on the witness stand, and I'm asking questions, and they say, well, I know that he shoplifted that day, and it's just that simple. He shoplifted that day, and I know it. But we have to take your word for that. You're the only person that was in the store. You're the only person that saw that. And now, transition time, you actually have a felony conviction, don't you? For assault and battery. And that was a felony that you incurred here in California Superior Court, and you took it before this judge, and you were sentenced based on that. Right now, it's tied to something. Now, we have to take your word for it. Now, we have to find you believable because you're the only one there. And now I put prior convictions after it because now it means something. And I've asked questions, or I've elicited my favorable facts already. So think about prior convictions it's easy to know what to ask, but when to ask it and where that block goes, I think, is the most important part. Acts of untruthfulness under 608B are by far probably one of the vehicles that are dropped most out in the world. Okay? If you poll trial attorneys and maybe even trial judges today, I guarantee most would either forget that this actually is a rule or not understand what it does. So you as law students and new lawyers are the ones that probably know the most about this rule, and that's a vehicle available to you. So all that means is you have to be in education mode. You have to be in mode to say, here's what this rule is, here's why I'm able to do it, and judge, if you need to, go back to the rule book because it says it right here, right? And this is, have they done something? Have they committed an act that is probative of their untruthfulness? And I get to ask about it. There's some limitations to the rule that I don't get to get into extrinsic evidence. I don't get to say any consequences of it. But the fact is, you lying on a college application fits under 608B. And I can ask you a question about it if you showed up as a witness tomorrow in my trial. And that's a discussion that could go off the tracks that some judges wouldn't get and your opposing counsel may not understand. Think of it as a vehicle that you have to go down. You have to investigate it, and then you have to ask it the right way. And then when the objection comes, make sure that you're ready to go over and defend it and tell them how it works. All right? But these are the things that organize your bullets. Prior consistent statements is a little bit different. And the reason it's a little bit different is I like to, right? Try to say this with a straight face. Let me see. I like to assume the best in people. On the record, I tell you, I'd like to assume the best in people, and I'd like to assume the best even on the witnesses that appear on the other side of my cases. And that is, I hope that everyone shows up that day is going to, regardless of where they came from before, regardless of what they said before, they're going to tell the truth that day. And hopefully my cross-examination style and the questions I ask encourage that type of behavior, right? So I hope that they're all going to tell the truth that day and I operate from that assumption. I craft the questions so regardless of what they ever said before, they're telling the truth today, and hopefully the truth, if I'm exploring it, is something favorable to my side. Right? Sometimes that doesn't happen. I know, it's a shocking thing, but sometimes that doesn't happen. Sometimes people do not tell the truth on the stand, despite the magnitude of the oath that they've taken. And what happens is when they go sideways, when they say something different, when they lie, and it goes counter to something they've said before, I can explore the vehicle of prior consistent statements. But notice, there's one thing different about this last category from all the ones above it. It is not something I necessarily plan out. I plan the fact that they didn't have the glasses on that day in perception. I plan for the fact that mom has a relationship to son and that may be a potential for bias. I've investigated and I plan to integrate in some way the prior convictions. And hopefully, I've done some investigation and I might even find a specific act of untruthfulness under 608B that doesn't rise to the level of a conviction. I plan for those. Those are blocks. Those are things I've organized in my cross. I figure out which one goes first and second and third and how I'll transition from one to the next. I think about the connections that I can make with the jury for each block. I don't plan a prior inconsistent statements block. Because you know what? I'm hoping that I get the truth this day. I'm hoping that I get the 30 yeses in a row and I sit down and I have available to me everything that I wanted in cross. I hope that I get it all. But when they said green light before, going into that intersection at Mission and First, and I said, you were there at the intersection. You were there at Mission and First. You were at a place where you could see the intersection and you could see the cars coming. And you had an opportunity to look at the light. And when you looked at the light, notice, I'm asking for the truth and I'm asking for the version I want. The light was green. I go on the assumption that they're going to tell me the truth and they're going to do what's right. That's what they said before. I'm entitled to go after it today. And notice, I'm not saying, which is a popular mistake in cross-examination, I'm not saying you said before in your statement. You said before in your deposition. No, I'm saying here today, you had a chance to look at the light and the light was green. And if they go sideways, if they don't do the right thing, if they don't honor the oath, and they say, nope, pretty sure it was kind of yellowish. I think it was in the red family, right? If they say something else that day, then I snap into this block. Even though I didn't plan it, I enter into this block. And I craft a block right away that goes into that. And there's a different video that we have and a different handout that we have that shows you how to accomplish that. And we'll talk about it in Trial Advocacy, and we certainly cover it a lot in others. But it's not something I plan out, even though it's one of the vehicles available to me.